There was a short Lori Vallow hearing after jury selection on the 29th, and the word used by many people to describe this was explosive. And the question is this how Lori is going to act during the entire second trial, or is she getting it out of her system pre-trial? So Lori said they did an aggravation phase last trial over her objection. And right off the bat, it gets good. The judge has to correct Lori that they in fact did not do an aggravation phase because she stipulated to it. If you didn't watch the first trial, and I believe I talk about this a little more later, the aggravation phase would have allowed the state to dive into just how terrible a person Lori is after being found guilty. They would be able to, from my understanding, bring up witnesses to call her out and talk about her. And Lori ran. Lori stipulated so that she wouldn't have to be embarrassed in that way across the world. So after that, after the judge explained what happened, Lori goes on a rant about needing to have a hearing before an aggravation phase. And the judge says he believes she's talking about the rules for a capital case, a death penalty case. Lori then says correct and has to tell Lori this isn't a capital case. And the last one wasn't either. Lori then says, well, in non-capital cases, you don't have an aggravation phase. And the judge corrects her. You have a guilt phase and then a mitigation/aggravation phase. The state jumps in to mention penalty phase. That if the aggravation phase isn't a separate hearing, then there isn't a penalty phase. Lori asks, what is he getting out of the aggravation phase? She wants to know why we're doing it. And the judge has to explain what he already did, or at least what I thought he already did in the first trial. This is for the jury to find if it was a dangerous felony, and the state has a right to try to prove aggravators to go against any mitigation at sentencing. Lori asks, shouldn't that be with the guilt phase? And the judge says, no. Lori says, will we have a whole other aggravator phase in this case? And the judge says, if the jury finds you guilty, which, I mean, let's be honest, I really was kind of waiting for him to slip up and go, when the jury finds you guilty, because I think we all have an expectation for the case, Lori included. And if state wants to proceed with aggravators, yes. And I have a little note here. From my understanding, the aggravation phase allows the state to go in on Lori. She is guilty, and here is just how terrible she is. I don't know if the Idaho cases can be mentioned or not, but Lori knows this phase will be broadcast, and she will not look good. There's more about the Idaho cases later, by the way. This is actually really short, but was a rather interesting appearance. That's why I decided to do a video on it. Lori says, then do we have to have a hearing for probable cause for these aggravators? And the answer is no. Lori says these are just alleged aggravators, and the judge says, correct. Lori says the grand jury never found probable cause for them, and the judge says, correct. Lori says, so if they find her guilty, an aggravator phase is added, and the judge says, that's what I said. Really, at this point, she's just repeating everything the judge is saying, but also either pretending she doesn't understanding it or not understanding it. And she gets her little, okay, like that high-pitched whatever, move on type thing. Lori talked to counsel for a moment. She actually talked to counsel quite a bit in this. Lori says the rule she is talking about is actually for non-capital cases. Well, Lori, then why did you agree with the judge? You were talking about capital cases earlier. Oh, because you don't know what you're doing. And she wants that on the record. And there's more talking to the counsel. Judge says she can challenge the state's allegation, but doesn't get a probable cause hearing. Lori says she is asking for the hearing and is challenging it. So she's not listening. The judge says the state's aggravators allege that this is an offense involving infliction or threatened infliction of serious physical injury. The offense involved the use of a deadly weapon or dangerous instrument during the commission of a crime, specifically a gun offense, involved the presence of an accomplice. The offense caused physical, emotional, or financial harm to the victim. The defendant was previously convicted of a felony within the 10 years immediately preceding the date of the offense. Now, I don't know how this works, I'm going to be honest. The defendant was previously convicted of a felony within 10 years immediately preceding the date of the offense. Is that she was convicted of the crime before the date of the offense, or is she convicted of a crime that was taken place within 10 years of the offense? I'm not sure how that builds, right? I'm not sure exactly. Using some context from later on, it sounds like maybe any of the crimes that took place before this could possibly come up, but I'm not sure. I'm honestly not sure. If you go off the dates that the children went missing, it's before Brandon, I believe. So I don't know what's fair game, to be honest. And I think that's why she doesn't want this phase. But they also include that defendant's character and background can be an aggravator. The judge asks her, what aggravators would the jury not be able to determine? Because a lot of them in prior convictions are pretty inherent. So this is where he says prior convictions are pretty inherent. So basically, if she's found guilty of this crime, most of the aggravators, he can't say 100%. He says like 99.8 at one point. Basically, they're pretty inherent into the crime. Like, you did this aggravator to then be found guilty of the crime, because being found guilty of the crime means you did the aggravator, that type of thing, but they still have to find it. And he mentions the prior convictions, and the judge asks, are you saying you don't have prior convictions within 10 years? And Lori says, no, I am not saying that. So again, I'm not entirely sure. Context wiggling in there. I don't think she had prior convictions before the murders and the attempted murders and the conspiracy to murders. I don't think she had, like, before her group did that, I don't think she had a criminal history. I might be wrong on that. So I'm not sure. I'm not sure how that all works. But I put it in there because maybe you can tell me in the comments. But Lori does say, no, I am not saying that about the prior convictions within 10 years. So maybe Lori doesn't know either. Lori asks which of them don't qualify the jury to make the determination, which made no sense. And the judge says that is the question he's trying to ask her. So the judge is like, okay, so which of these aggravators do you not think the jury is going to be qualified to be able to answer? And then Lori asks, well, which one of these will the jury not be able to determine? She's like a parrot today. It's really weird. The judge asks if she is found guilty by the jury, which don't you think there is sufficient evidence for the jury to decide? The judge explains, for example, if they find you guilty that someone was shot at a victim, that is an aggravator. The jury would know a gun is used. The jury would know about the accomplice, your brother. If someone is shot at, the jury would presume emotional harm. So the judge struggles to see what is lacking for the jury to make those determinations. Lori says this didn't go to the grand jury. She wants a hearing. The judge explains she is confusing two different things. An aggregator is not an amendment to the charge. So basically, Lori is arguing that aggravators are a change to her charge, which they aren't. And that's the whole basis of this. The grand jury, in fact, did find it dangerous for the offense. And then Lori asks, why isn't this mixed into the guilt phase, which gets explained soon. Lori says there is one sentence for this charge, so why do we even need to have the aggravator phase? And the state says the state is involved now. The state says the jury does not make a finding of dangerousness as part of guilt phase. So they have to make a separate independent finding after which the defendant guilty of the dangerous finding, which will include the use of a weapon or intentional infliction or threatened infliction of physical injury. The jury has to make it as to the dangerousness. The judge wants the state to explain why they even want to do a aggravation phase given the circumstance. And the state says, in all honesty, it comes down to appeals. Case law can change. She already had to do a redo of a phase and re-impanel a jury before because of a change in case law. So it's just kind of, covering every base, so Lori has nothing to stand on. That's really what it boils down to. The state can do it, so they're gonna do it. Now, with that being said, I don't know if I put it in my notes, but the judge at one point does explain, you don't want to combine the guilt phase with the aggravator phase with a jury, because if a juror is wondering whether you committed a crime, you don't want them also answering a question under the assumption you did. Is it an aggravator? It could mess up a possible not guilty verdict, right? Lori again argues how they didn't find it dangerous, and the judge explains that with a gun it is highly likely they still need to make that finding. The judge is basically, it's a formality. Let's be completely honest. This is a formality. This is a formality to future-proof this, to not give Lori another revenge to her trial. That's what it is. Lori asked, but aren't aggravators for sentencing? And there is only one sentence. Can't give her less or more. Judge has to repeat what the state said about the appeal, and that the state has the right to do it. And that's really the end of the problem, right? The state is allowed to do it. They're going to do it. They don't have to, I don't think, tell the judge why. I don't even know if it's proper for them to ask the judge why they want to do it, because it's their right to do it, right? That's something where it's like one of those moments where I'm like, I don't know. It was for Lori's sake, and she's not going to appreciate it, right? There's a lot of that in this, actually. Lori says so she isn't entitled to a hearing for aggravators not found by the grand jury, and the judge said he's trying to explain. The grand jury did find it's a dangerous offense. Lori interrupts him to yell, but they didn't find these specific aggravators, and the judge has to get loud and ask, can I finish what I was saying? I didn't interrupt you. Can I finish? The grand jury found the dangerousness, and you aren't entitled to a hearing on the other aggravators. Just very simple. You're done, right? Lori asks, when is conspiracy to murder not a dangerous crime? And the judge immediately claps back. I think he was preparing for this question. He says, when someone says they're going to choke someone to death and don't actually do it, that's not a dangerous crime. Lori says, so an instrument may or may not have been used as a dangerous crime, correct? And these aggravators talk about something totally different, don't have to be found after that as a dangerous crime, correct? And that's supported by case law. Yeah. There's still more. I told you it was short, but there's a lot compacted. So that when you go to appeal, you can't say it was not a dangerous crime. The judge, that's what Lori said. The judge says, I don't know what to tell you, and explains, a judge used to decide aggravators, but due to a decision, now a jury does it. Guilt phase is separate because you don't want to confuse the jury. Lori asks, how do the aggravators change anything? And the judge says he doesn't know how else to explain it to you. Do you have any other issues? That is the judge saying he's done. Lori says yes, but wants to finish this first, because of course she can't stop. So you're denying my motion to have a hearing on this. And he explains it's denied for all the reasons said before. He actually explained the reasons, but I'm not repeating it. I'm not a parrot like Lori. She isn't entitled to it. Judge says 13.5 is you get a hearing if they amend the indictment. They didn't amend the indictment. Lori says, this isn't an amendment? And the judge answers, no, it's not in the indictment. There is a difference between an aggravator and changing the charge. Lori says she doesn't want an aggravation phase, and the judge says you don't have to attend if you don't want to attend, you don't have to attend. Butchered it there, but he literally told her you don't have to come. She's probably just going to stipulate to it again, and she's probably not going to put on a defense again. We know that. I get the feeling after my guess is what might have happened is her counsel is like, you really shouldn't have stipulated to it because it hurts you on appeal. So she doesn't want to stipulate, but I think she will again, if it comes down to it. Lori wants headsets for her whole advisory council, and he says he can only give so many headsets, but they can take break. He explains that there's only 5 headsets that work in the system. He needs one, the state needs one, the court reporter needs one. Lori gets 2, one for herself, one for counsel of her choice. Lori says, you're making me choose between who helps me. And he says, sure, but technically you're representing yourself. You don't even have the right to consult. And he corrects himself. you have a right to consult with them, but it's not a necessary thing because you are acting as your own attorney. You're expected to proceed as your own attorney. They don't have an affirmative duty to even give you advice under the case law for being advisory counsel. The fact that they do is probably helpful to you, but you chose to represent yourself. It means you are supposed to act as your own lawyer. Lori snaps back as if she thinks this is a great thing. You appointed them and assigned them to me. I did not ask for them. So? Judge says, yeah, I did in case you decide not to represent yourself so they can step in at trial, which is still possible, Lori, but you're not going to do it. Lori asks, as an alternative, to do sidebars at the bench so they can be more involved. The judge says, depending on the complexity of the question, single questions will use headsets. And this I'm confused on because I don't think she was allowed to approach the bench. But maybe he's thinking, actually, I don't know what he would be thinking. Is he going to let her approach the bench? Like at first when I wrote this, I was thinking, let her staff approach the bench. But they wouldn't have Lori's side of the conversation if she's at the table. So I don't know. I don't know what he means. Maybe she'll be allowed to approach. Lori asks, what does the state intend to bring in from Idaho so Lori can prepare her questions without being accused by you, to the judge, of opening the door? How can we avoid that when most of these witnesses testified in the Idaho trial? Judge says he will ask the state to tell witnesses that the questions won't require testimony about prior testimony or proceedings, and the state agrees. They could be advised that if a witness thinks Lori or the state are going that route, they can request a break. The state still wants 4 alternate jurors because they lost 2 in the first 2 days last time. Basically, this is in talk of possibly not having a jury selection tomorrow. Lori doesn't want to waive any appeal issue that wasn't random for whatever reason, and the judge explains that there's a theory that people that might show up in person that wouldn't remotely, and that makes it less random. So it sounds like maybe 1 jury selection's in person and 1's remote. At this point, all videos of the proceeding I saw fully cut off. I don't know if they're doing jury selection tomorrow. There's a variety of cutoffs actually for this little bit, but the longest I could find cut off about there. So there's a little update. She's still getting snappy. She was more snappy with this judge than the judge earlier today. Maybe she's tired in the afternoon and whatever. She failed today, remember, to remove this judge, and now she's stuck with him again. And I wonder if this is going to be the normal for her. Is this going to be her normal for the whole trial? Is she getting her rage out right now? How much is she going to show the jury when we get into it? Is she actually going to try to have an aggravator phase this time? Because I guess technically that gives her more to work with on an appeal, even though it's probably doomed to fail. I guess we're going to have to see.